Hey up there, legal warriors. In this video, I'm going to cover what you can do to help your attorney in your criminal case in Washington State. There's certain things that you can do, and sometimes the way you can help is avoiding doing other things. If you want to learn how to help your attorney, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Lynnwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 25 years. By putting out these videos to help educate the public. To find this useful, please like and please subscribe. More people get to see it. More people get the help they need. Now I'm just going to jump right into it. How is it that you can help your attorney defend you? And believe me, I understand from representing clients for 25 years the anxiety that somebody feels when they're charged with the crime, and there's all this waiting around and all this wondering about what's going to happen, all this idea about maybe how court works and what they've seen on TV and why aren't we doing something and why can't they understand that I didn't do this or I'm not a bad person, I'm afraid my life is going to be ruined. All that is going through a client's mind or somebody charged with the crime. And so they want to know, hopefully, what they can do to help. And so here's what I've come up with about how somebody charged with a crime can help their attorney. Step one is when you meet with your attorney, you need to tell them the whole story. Tell them what happened because it's confidential. Now, if the attorney tells you, don't tell me X or don't tell me Y, there's a reason why. Like in a very serious case, if, somebody, got, their head chopped off or something, and you are a suspect in that, we might say, hey, don't tell us anything about that if it happened, because attorneys are limited about how we can defend someone based upon what we know or don't know. But that's an extreme example. Step one is, hey, go ahead and tell your attorney what happened. Don't hide things from your attorney, because the more we know, the more we are able to deal with the situation and use our vast knowledge and experience to deal with what really happened. And part of that also is when you are telling an attorney what happened, realize that oftentimes we don't care as much about the fact pattern of the case as you do. And that's because at a lower level crimes, non-felonies, and the vast majority of crimes that are going to be defended are non-felonies, DUI, assault, theft, right, things like that. We want to know about the person and why it is that you got here, because it's telling the person's story on top of the what happened story that lets us get outcomes. And so I just came out of 2 client appointments where I was asking people about who do you live with and what does your loved one sound like, and are they supporting you or not? Are they mad at you or not? Do you have any pets? That's your support system. What are your wishes? What's a bright and shiny version of your future look like? What are you afraid of? What are you frustrated by? And these sometimes can be off-putting to a client, because they go, why aren't you talking about the field sobriety test? Why aren't you talking about whether I was speeding or not? And those things are going to be figured out once we get police reports and stuff like that. It's the personal stuff that will allow us to not only tell your story better to the prosecutor or in court, but to help support you emotionally. Because a really great attorney doesn't want to just fix the case. They want to help you get through it, because it's the human factors that created the case. If we deal with the human factors, not only are we helping the human, we're helping make sure there's no other cases, and we're helping solve the case. So tell your attorney everything, and don't be put off if we're asking questions that don't seem to be just the facts about the case, because attorneys who play just the facts end up losing cases. Guess what? Why we're in the situation is just the facts is written totally against us by people who are going to swear that happened, that have guns and badges. So let's try to work with our version, but also work outside of that. What's the second thing you can do? Seems obvious, but try to do what we tell you to do, right? If we want you to go get an evaluation to show you don't have a drug or alcohol problem, get it done. If we need you to do some classes, anger management or MRT or some type of drug or drug classes, whatever it is, we're going to tell you what to do. Try to get it done. If we need you to do counseling, try to get it done. Remember, any type of affirmatives, classes, education you do cannot be used against you to show that you did a crime. It's to try to help, not only help you, but help show the prosecutor that you're a better risk, right? We're addressing the problem for whatever got us here. And if you do those things in a timely manner, is going to give us more of an ability to help you. So many times people drag their feet, life gets in the way, they don't want to do things. It's important you try to follow the instructions. And if the attorney tells you not to do it, well, then don't do it, right? Sometimes it's not time to do that. Sometimes we know it might be a waste of money, or it might be what the prosecutor doesn't want you to do, because remember, law is local. A court in one county will want to see something different than a court in another county. And if an attorney is doing their job, they're trying to have you do what will actually help get an outcome from the authorities that are the ones that are controlling, the prosecution side of thing on your particular case. A case in Linwood in a municipal court is way different than a case in Linwood in a district court. And it may be a municipal court or district court based upon where it happens. And so do what the attorney asks you to do, and also avoid doing what we tell you not to do. Step 3 is preserve the evidence, right? Preserve the evidence. If you have text messages on your phone, sometimes it might take a year or two for a prosecutor to file a charge. If you've got text messages from that relationship that might show that, hey, the other side was the one causing the problems, the girlfriend or the boyfriend, or, that the neighbor or whoever, save those text messages. So many times people delete them because they want them to be out of sight, out of mind. And, maybe there's a way you can save them through a computer program. Those exist out there, and then delete them on your phone, right? But we need you to save the evidence, because so many times there's some great evidence we could have used, right? But it doesn't exist anymore because our client got rid of it. Or, hey, I don't have the photo I took of the bruise anymore, or I don't have the broken potted plant, that my boyfriend threw at me, and that's why I responded in the way I did. It's just try to save it, because sometimes a picture or a piece of evidence is worth that actual 1,000 words. And hang on to that and let your attorney know you have it. And that is really important as well. Now, step 4 I've saved to the end, and this is the most important one. And why I saved it to the end is because it's more about what not to do. What we need you not to do is we need you not to be the lawyer in the case, right? The reason why you hire a lawyer is we actually got trained, first of all, to know what the law is, not what you think it is, not what you wish it is, and not only know what it is, but know what it actually is in court and how it's actually happening in court, not how it should be or how we want it to be, but how it's being done in each particular court. And when you try to micromanage your attorney and try to think you know more than your attorney, you really piss your attorney off, okay? And when you piss your attorney off, some of us, like me, who's done this for 30 plus years, easy for me to handle. A younger attorney, sometimes they can shut down, right? They could say, how this person is so hard to deal with, and psychologically, you might lose your attorney. You might lose them to the degree where they're not doing as much for you as you might want them to do. So it's okay to suggest, hey, have you thought about this and have you thought about that? And we really want you to come up with, hey, I've got this witness you might want to talk to. That stuff's fine. But trying to micromanage your attorney, hey, you should be telling the prosecutor this, or why haven't you went and done that? Why is it that you haven't, already interviewed this witness? And we're going to know the reasons why, and you don't know them, okay? And I'll tell you right now, why don't attorneys interview witnesses right away? Because number one, usually when you interview a witness, it activates their interest in the case. We don't want things activated, and you gotta wait. Witness interviews are at the end. You want time to pass, and they have to be in a certain order. And if you're talking about interviewing a victim, it's always the last person we talk to, because we have to have the most amount of evidence to use to try to trip them up. It's the same reason why typically police interview the suspect last. They want to talk to everybody else first. If they know who the primary suspect is, that's who they interview last, because that's what works. But on the defense side, realize we're trying to keep you from having to be exposed to the idiots on the jury, okay? The people that can't get out of jury duty, who are going to think people are guilty because they're accused of a crime. That's how tribalism works. That's why you don't see a whole lot of not guilties at trials, even with the best firms. And so once you get down to witness interviews, prosecutors shut down. They have to be involved in it. All offers are off the table. Now you're set for trial. That's the last part of it. If we can't get someone out of things without going through that, then that's what we go to. And sometimes now the case is older. They don't care as much. They remember less. The case is worse. So what you think in this hypothetical should be done is absolutely the worst possible thing to be done. in most cases, not in every case is different. And if you're thinking you're the attorney and, oh, you're not doing anything and XYZ, number one, you're wrong. And number two, you're hurting that relationship with the person that you trusted enough to hire to help you get out of this mess. So, you can share when you're anxious. You should share when you're anxious. You should communicate respectfully to your attorney, and that's what you should expect back in return. But trust the attorney that you hired to do the job that you paid them to do. Because if you hired them, they're probably a good attorney. You didn't hire a bad one, right? If you hired a bad one, you wanted the lowest rate, well, you get what you pay for. All bets are off at that point. So let's go over it again. What is the thing we avoid? Micromanaging what the attorney does, because, of course, when we do that, you're hurting the relationship, and you're probably having the worst possible outcome is if the attorney gives in to what you want to do and they start to do things they know are not right for the case. And strong attorneys will stand up, and weaker attorneys won't, and just don't put your attorney in that position. So anyway, that's my list. 4 things. I hope you found it useful. If so, please like and please subscribe. More people get to see it. More people get the help they need. And more importantly, if you have a criminal matter in Washington State, feel free to reach out to our firm. If we get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.